I was born in 1945. 1.4 million males in the United States were born in 1945.
We are not our own.
Obviously, the military is not an easy way of life.
God was working when I did not realize he was working.
I absolutely loved my career.
The Lord used me in many ways in the military. I was able to help people. They would come to me when they had problems. My nickname was Preacher.
Or outreach person.
And so there was a lot of good information on wanting to connect with the community. And that's what attracted me. And then we tried to get together, and he was really busy, and I was really busy. I did meet with his mom here in my office about a month ago, and we're not here to advertise him as a lawyer that you might need, but to pick his brain a bit. And certainly if you need a lawyer, you could talk to him, but that's not his purpose for being here. Just to pick his brain a little bit about issues that are pertinent to senior adults. And so we're glad to have you with us today, and thank you for being willing to come. And he is going to have lunch with us. So like I say most time, make sure you let him have lunch. And don't keep him hostage here very long. And then sit at his table if you have additional questions.
I'm happy to answer questions.
Thank you for being here, and we're excited to hear what you have to say.
No, thank you very much, Joe. Thank you, First Presbyterian Church. Thank you, Key Program. So, who am I? And why am I here? My name is Shann Chaudhry. I'm an attorney. I have been practicing law for 19 years now. And most people stop there, right? One of the first conversations I had with Joe today was like, what's the deal with this, right? This is a lot. And the idea of the zebra. So when I was trying to come up with an idea of what represents what we do and how can I convey it in things other than black and white text and, charcoal gray suits, what does that look like? And our values are empathy, authenticity, education, gratitude, and service. And empathy is a really big part, but in order to have empathy, you have to connect with people and you have to be able to get to really know people. So through getting to know our clients, and from our clients getting to know us, we build really close connection. And well, what does that mean? So everybody's different. And the idea that I can put together a plan or meet your needs based on some sort of cookie cutter template is just completely wrong. It's a falsity. Everybody has different wants, needs. They have different casts and characters in their family. And life is a whole lot different than it used to be. Things move faster, technology's involved, and everybody's different. So a zebra, if you did or didn't know this, every zebra, their stripes are all completely different. So no one has exactly the same stripes as the other, just like no one has the same needs as another. So through that close connection and discovery, we can find out what a client wants, who they are, what they need, and how we can serve them. And then that also goes with our overall goal of how to best serve the community as a whole, how to provide education, which is important to me, because there are so many things that I deal with on a daily basis that are problems that if somebody took a second and paused and consulted with somebody, they could have avoided something that caused a huge pitfall for their family or for their estate. So I'm going to talk a little bit about that today. But the whole idea is for me to better know and serve my community. I've been in San Antonio since 1989. Sarah's mother was my reading teacher when I moved here, and I went to St. Mary's Hall for 12 years, Trinity University, and St. Mary's Law School. Worked at a firm for 4 years, and I opened my own firm 13 years ago. So it's been a journey. I am a father of 3. I have an 8-year-old named Isla, a 10-year-old named Violet, and an 18-year-old named Charlotte. And raising girls, I learned that there's a lot more screaming than raising boys is involved. So I started really building my business in 2016, 2017. I had a lot of life changes myself, and I got really clear on what I wanted to do and who I wanted to serve. And it was just really important to me to figure out how to give back, because I feel like everyone has that responsibility. And if I can give up a couple hours a week to give answers and guidance to people that would save them hours of heartache and spending money and fees on lawsuits, then I feel like it's my responsibility. So with that being said, I have built the team that we have. We have an office in San Antonio, Austin, and Dallas. I've got a team of attorneys and support staff to help provide service to clients and to provide information. So one of our big initiatives that I'm asking for everyone's help with today is we give away a certain amount of plans per year based on the numbers that people that come to us and hire us. We give one plan to a person in need. It's usually somebody that's going through, that has an indigency problem, or they're very well deserving, and we give one away for everyone that comes to us. The problem, surprisingly, that I have right now is that I'm not getting enough nominations and volunteers that need the service. So I'm going to provide some information to Joe to pass around. So if you know somebody that's in a tough spot that needs representation, we provide that pro bono work as part of our service initiative to people that deserve it. But that being said, attorneys like to talk, right? And nobody wants to hear me give a PowerPoint presentation about planning or, the virtues of doing that. So what I like to do is do a little bit more of an informal process, and I'll ask some questions, I'll get some responses from you guys, and then I like to direct our discussion based on the needs, desires, wants of the people that attend. So that's what I'll do. But That being said, can I get my little graphic? Let's start with something a little funny. This is a meme. I don't know if your kids or grandkids send them to you, but they post them on social media. This is a picture. It says, "Taking Mimi to get ice cream cone as a reward for removing the rest of the family from the will." I would laugh, but I deal with this at least once a month. And it's sort of problematic. Not to say that it's not warranted sometimes, but these are the kinds of things that people don't realize that can happen as planned. I deal with a lot of husbands and wives that come to me as they're approaching retirement, and they're like, "We've got a plan. And this is what we're doing, and it's being implemented." And sometimes one of the partners is stronger than the others, or they're the person that gets things done. They're the ones that take care of the bills, the tax returns, making sure things get done in the way that they're supposed to. And they're usually the person that's in charge of that plan. Well, sometimes that person is the first person to pass. And they leave somebody that needs extra care, that needs direction, that needs those things. And sometimes the family all band together and they provide that. Sometimes a couple of people do that, and sometimes one person does it. Or sometimes one person does it and the others pay for it. There's all sorts of different circumstances and scenarios that I've experienced in dealing with this. But the idea that if you guys go in and you make a plan and you think that it's done doesn't necessarily mean that it won't change or that it won't be changed later, much to your chagrin. So one of the things that we see a lot is that people, as they get older, and of course probably no one here, there gets to be a point where some of our executive function changes, and we decide maybe we're not going to file taxes this year or pay the IRS, or I'm going to do what I want. And I like Becky because Becky comes over and talks to me once a week, and I'm going to leave her my house. Those are the kinds of things that we deal with, whereas the family that's been supporting and taking care of things finds out after the fact that that's happened. So what does this mean? It means that not only do you need to have a plan in place, but there needs to be discussion with the family about it. There needs to be open, honest conversation. And sometimes that's through what we call a family meeting. And in family meetings, you can discuss as much or as little as you want to. So we've got a plan. This is the plan. Something happens to me, this is what happens. Something happens to my spouse, this is what happens. If something happens to both of us, this is what should happen. Not, you're going to get this, and you're going to get the house, and everybody go put stickers on things. That's not, it happens, but that's not what should be happening. What it should be doing is setting expectations. It should be setting boundaries, and then communicating what, the overall goal is. But it's hard to do that because a lot of people don't want to face the unfortunate reality that all of us have limited time on this planet. And so sometimes people put it off, and they 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 may have a plan, but their family doesn't know about it, or some people decide that they're going to change the plan after it's been placed. So getting through that, I want to know, of everyone here, by show of hands, how many people have a will? Excellent. Good job, guys. So a will is a document that says, in the event of my demise, I want a person put in charge of my estate, and I want my assets to be allocated to this person or these people. And that's essentially what it does. It is not automatically binding and effective upon your signature, though. That's a big misconception. A will is only valid when it's taken to court and it's gone through probate, which means somebody goes to court, they get appointed as the executor, and the judge admits the will as the last will and testament of the deceased. And then it becomes effective. So there's a big misconception of what exactly a will does, and if you have a will, you get to bypass probate. That is not the case. By having a will, you have a plan, and you have somebody that's in charge, and that is a bare minimum that anyone should have. But it does not govern what happens in the event of your incapacity. So that's a big thing that people have to realize, is that's a separate issue. In the event that you can't make decisions for yourself, usually your powers of attorney kick in. So Texas, we have two flavors of power of attorney. We've got a medical power of attorney. So if you can't make medical decisions for yourself, you appoint a medical agent to make those decisions for you. And if they're not available, there should be at least 2 backups. My recommendation to everyone here is that you have a primary and 2 backups. You also need to make sure that their contact information is readily available, and if there's an emergency, that medical power of attorney is on file with your physician and your preferred hospital. Beyond that, we've got the other power of attorney, which is called the general durable power of attorney. And what does that mean? It means that you're giving somebody to act on your behalf with regards to all of your family business. That means talking to your mortgage company, paying your taxes, applying for government benefits, talking to your insurance company, if you've got a business, running the business, making gifts, dealing with your email accounts, all sorts of things. So you always name a primary person that makes decisions if you can't make them for you, and I always recommend 2 additional backups. Those 3 documents are the heart of any estate plan. Estate plan is a fancy word for a plan. You know, estate comes from the idea of England. Estates were houses typically, not what we think of estates as American, which is like, you know, lifestyles and the rich and famous kind of thing. So the estate plan is those 3 documents. Of everyone here that has a will, how many of you, is it less than 5 years old? By a show of hands. Okay. Of all of you here, do you have powers of attorney? Okay. By a show of hands, how many of those are 5 years old or less? So, the law says that if you have this document, this is what should happen. Private companies have a right to contract and choose their own terms and services. So something that we find out, and that I found out through hardship and experience, is that some financial institutions don't like to honor powers of attorney more than 5 years old. They've got legal departments, there's lots of lawsuits about them, and generally speaking, the newer the better. So my recommendation is you should always re-execute your powers of attorney every 5 years as part of an overall estate plan review. And that doesn't mean going and hiring an attorney or something like that. That means sitting down and reviewing with your inner circle what's in the plan, what needs to be done, how recent is it? Do these things still apply? Because we always remember, okay, who's the first person in charge? Oh, my responsible son or friend or daughter. Well, who's second? I don't remember who I put. Who's third? I don't know. People change, they come in and out of our lives. It's one of those things that you should revisit regularly to make sure that it still serves your needs. If you have that suite of documents in place, most of your needs are taken care of, but you'll have to go through that probate process, which is not, if you have a pretty simple estate, it's not that onerous. It takes 6 months to a year. The attorney's fees associated with it are typically $3,500 to $6,000 per estate that you have to go through. And it's just a bureaucratic process where you have to file notices with the court and in the newspapers and provide inventories and do a number of things. So if you're all right with that, then you're set. But making sure that your plan is in place, that reflects what your needs are, is more than important. Some people don't do anything because they don't want to think about what happens when they pass away. And it's not an uncommon thing. So what happens if you pass away and you don't have a will? You go through something called intestate administration. And that means that the state of Texas decides who your heirs are, who's in charge of your estate, what they get, and it is a highly bureaucratic process, takes lots of time and takes lots of money. To the extent that you have a simple estate, it still takes at least a year and about $10,000 to go through intestate administration. So we've got wills, we're solid. You have 4 years from the date of somebody's death to probate a will. So what happens is usually one spouse passes away and they live in a house, they had lived in a house with the surviving spouse. Surviving spouse, they're co-owners of all the accounts. They don't need to do anything because all the accounts are already signers on. They need to sell the house. They wait more than 4 years. Guess what? You didn't probate that will, so whatever the deceased spouse wanted doesn't control anymore. And what's the law of the state of Texas now controls. So for some families that have blended families or black sheep, this is highly problematic because now the surviving spouse is not the only heir to the property, but we've got other people that may be not necessarily adverse, but not the best people to have to interact with, and then they usually want some sort of money, and it can cause friction in the family and things like that. So one of the biggest pitfalls is if somebody passes away, they have a will, you need to probate that will within 4 years of the date of death. Otherwise, the will does nothing. So super important there. Some people decide, I'm just going to gift everything. I'm not going to do a will, I'm not going to do powers of attorney, I'm just going to gift it all away. Now, the problem with that then becomes to the extent that they ever need medical care and they can't pay for it themselves, they have to go and apply for Medicaid. Medicaid is a program that's available for people that have less than $2,000 in assets and make less than about $3,000 a month. As an individual, for a family, it scales up. But if you've made any gifts in the last 60 months, retrospectively, you are disqualified for some period of time. So if you made a gift, the only thing I have is a house and I'm gonna leave it to my son. I'm just gonna deed it to him right now. Well, you've lost your homestead exemption, you've lost your over 65 exemption, and you've just made a gift that disqualifies you from Medicaid. And it's not fixed by just deeding the property back. So that may not apply to some of you guys, but it might apply to your parents. We've got a lot of people whose parents, that's what their plan was, I'm just gonna deed it to you. Well, mom's now 98, she needs Medicaid because she's outlasted the money that she's had on hand, but she gifted away her house, so she doesn't qualify. So now we have to wait, and the family has to out-of-pocket mom's care, whether at home through attendance, somebody has to sacrifice their job and their time, or they pay between $8,000 and $12,000 a month for a home. So, to prevent that entire scenario from happening and leaving that burden to you or to your family, make sure you consult somebody before you're making gifts. It's a hugely important thing. It is a pitfall that many people fall into. So I've sort of talked about some big concepts and wanted to at least preface a lot of this before I go into any specific questions. But I'm here to serve and to answer any questions that anybody may have with regards to issues that they've seen or that a family member or friend may have. Does anybody have a question? Yes, ma'am. So you can have them as an authorized signature person, right? Which is an authorized signer. So having somebody on your account at the bank they're either a signer or an owner. So if you add them to your account and make them a joint owner of the account, then it's potentially a gift. So that becomes a problem with regards to Medicaid. If you just have them as a signer upon your death or incapacity, there's definitely issues upon your death, and there may be issues upon your incapacity. But if your daughter also had power of attorney during a period of incapacity, you provide that fully executed power of attorney that's less than 5 years old to the bank, it shouldn't be an issue. The moment that somebody passes, though, the bank they'll freeze the account and say, we need letters testamentary. What does that mean? We talked about probate, we talked about will, that's none of the things this guy has said today. Letters testamentary is what the court gives you once they've appointed you as executor. So you have to go through that probate process and do that. What becomes problematic is that you're not going to be able to access that money for 6 months. So unless your plan involves having access to some sort of liquidity in the short term, questions need to be answered like who's going to pay for dad's care in the interim if mom passes away? Who's going to pay for funeral services, burial, things like that? Are there insurance policies that cover that? There are tons of solutions to this, but these are the discussions that have to be had along with putting together the 3 documents that I talked about. The documents themselves aren't the whole solution. Accounts can have payable on death beneficiaries, which can be a great solution for small families. What it is not a great solution for is someone that has, we want to leave an account to somebody and a house to somebody, but the house is in the will. Well, they've got to open a probate, they've got to pay the expenses for the house in the meanwhile, they've got to pay any other estate debts, they have to do all of this stuff, and the money that they have access to is locked into this house. And the child that's been left the account or the insurance policy, they don't have to do anything with that money. They don't have to pitch in, they don't have to. And there's a lot of thought, well, my kids, they get along, they'll do it. It's a coin flip. Absolutely best case, it's a coin flip. Because sometimes family dynamics change when parents pass away. Sometimes things like this cause huge amounts of friction. And it doesn't necessarily mean that one child is going to pitch in on those expenses. They may leave one of your heirs holding the bag in that regard. So it's really important to make sure that there's an entire plan and strategy as to what's happening as opposed to trying to ad hoc, like as you need to implement tactics like, oh, I've got this asset, I'm just going to leave it payable on death. Does that answer a question for you? Well, I'm happy to get into some specifics for you. Right. No, so I think that really what it comes down to is when somebody's on your account, you need to find out, are you signing an authorization form or are you transferring ownership for them to use it?
Make sure they have a power of attorney. Is that the key?
I would make sure that they have a power of attorney and that they are an authorized signer, not the owner of the account. Does that make sense?
Yes, I think.
So double check, right? But that's a simple conversation that that we have regularly with people that have foresight, and sometimes it's a more complex conversation that we have with people that didn't know that. But I'm here today to help provide information like that so that you guys don't fall into these problems. Yes, ma'am. Yeah, sure. So it will allow them to pay. So absolutely. So if you've got a child that's listed as an authorized signer, do they have authority to pay bills? They do while you're alive. So they have the authority to do that, but the breadth of their authority is not defined. By having the signatory power with the bank and a power of attorney, their responsibilities are defined in the power of attorney. And also their accountability is defined in the power of attorney. Anybody that's a power of attorney holder has a fiduciary duty, which is the highest duty recognized by law, to put the interest of the person that they're serving first. So if somebody has a fiduciary duty and they start making gifts to themselves, it's actually a breach of that fiduciary duty. It's self-dealing. So if you have somebody that has a signatory right on your account, you want to make sure that you've got a corresponding power of attorney. And that can be part of the conversation that you have with your family. And we're going into the holidays, and this is the time where awkward conversations are had around many Thanksgiving dinner tables. So sometimes this conversation comes up. And it's better to have it and be awkward than to not have it. And I find the families that do have it, they tend to have less problems. Yes, sir.
Could make some comments, please.
Yeah, absolutely.
I was in commercial banking for 27 years. I worked at 7 different banks. The first thing that happens when you receive a notice someone dies, they freeze the account. They immediately pull what's called the signature card. The signature card determines who has rights to that money when the people are alive. When they die, then they look at what happens to the money after that. Now, every bank I worked at, we did not recognize power of attorneys. We would not accept it. The reason for that is they can sign a power of attorney this year, next year they can sign another one. And so you don't know which is the most current.
Right.
And so we never recognized that. And when I talked to people and they would come in after my mother's family died, they were always amazed that the signature card was made out the way it was, that they were not the beneficiaries. A signature card overrides the will. If someone is the beneficiary on an account and someone dies, the next day they can come out and take all the money out of that account because it is theirs. If they are not, then it has to go like through probate as to who has right, and then you have to do the letters testamentary. But I always tell people, I tell my family, and when we open up a signature card, I always demand to see it to find out if it is made exactly as we want it to.
Right.
And all of ours were joined with the right of survivorship. If I die, my wife gets the money. If she dies, I get the money. And then we have beneficiaries after that. But the signature card is really critical, and a lot of people don't understand that. When you open up an account at a financial institution, it overrules everything else. So it's critical that you know how you filled out that signature card. And it's best that you do it in person. Don't do it online. You need to go in and talk to your banker and tell them exactly what they want to do.
No, thank you for sharing that. I think that one of the most important things is that banks used to be a relationship thing. We're lucky that we're in San Antonio. We still have few relationship banks where the same people are there. But my experience is that it's still becoming more of a revolving door. So the guy that was your banker for 20 years may retire. His predecessor or his successor may only be there for a couple of years. So they won't necessarily know you and your family and your desires and your needs. And just like this gentleman said, if you have a beneficiary designated on the account, it completely overrides the will. It's called an extra testamentary asset. So insurance policies, retirement accounts, investment accounts, annuities, CDs, all of these things can have payable on death beneficiaries. And if a person is listed there, as opposed to your estate, or that it's left blank, because if it's blank, it goes to your estate. But if a person is listed there, it's going to pass outside the terms of your will. So that's important distinction to make. And then with regards to the powers of attorney, I will say, yes, some banks don't accept them. I'm seeing more that accept them, and they require a signature from the person acting as power of attorney signed under oath that the power of attorney is currently valid and that it hasn't been revoked. And then to the extent that it is ever revoked, we file a revocation in the property records and we notify everyone that had a copy. But that's why banks sometimes don't necessarily want to accept things, and sometimes they want to use their specific forms. But if you have an attorney prepared form or a statutory form, they will usually accept it, is my experience right now. You may have to escalate it to a higher level banker than a teller, but usually they will. Absolutely.
Do you need a medical power of attorney for a spouse? Like if my wife was incapacitated, she was in the hospital, could I make the decision for her? Or should she get one?
best practice is that she get one naming you. And the reason is that sometimes people disagree about treatment protocols. They disagree about whether or not surviving spouses are fit to make those decisions. And it's by having a clearly executed document, it gets rid of all of the ambiguity. It sets those boundaries and expectations. So yes, I would recommend a power of attorney. And those forms, the medical power of attorney, the durable power of attorney, and a basic will, there are free forms on the Texas Supreme Court's website. The Texas Supreme Court started an initiative a few years ago to provide accurate, solid forms to the general public at no cost. And one of our initiatives is that once a quarter we have a workshop and we have people fill those out. We charge nothing for it. So if people need to come in, they want to have an updated power of attorney, I'll make sure that I get with Joe to make sure you guys know when that date is. And so it's open to the general public. But it's really important that you have those because it sets expectations and boundaries. A bank signature card is a private contract with you and the bank's policy. It doesn't say what you want to happen. And that's really what this is about, is what do you as an individual want to happen? Who do you want to be in charge? Yeah, so
She wants me to handle everything if I'm still alive. So how do you put that in the will?
well, you need to be listed as the primary. So, and that's pretty standard. We have, so the first named executor is the surviving spouse, and then we have second and third alternates are kids usually. No, it's a great question. You don't have to have somebody other than your spouse. Some people name someone other than their spouse if their spouse already has a diagnosis or they have medical needs or conditions that prevents them from going to the courthouse and hiring an attorney and dealing with those logistics. They just leave it to a child or a trusted partner. So I will say that the same scenario does not apply for everyone, but we go into professional preferences. My preference is that you use categories unless you were very specific. I'm leaving this family heirloom, this china cabinet, this very important thing to this person, as opposed to naming accounts. The reason that can happen is those accounts can change. Banks can merge, account numbers change, and I don't know how much time is going to transpire between this version of your will, the next version of the will, and when you pass, and what's going to happen during that time period. So my preference is to address assets by category, and then as we're doing this, okay, these people are going to split the accounts, this person's going to get the house, this is what this looks like, and then you talk about, with your attorney, what does this look like in practical application as part of the probate? Like where the rubber meets the roads. We're making all these plans. This person's getting this person's getting this. How is this all going to come together? And I don't want my kids to fight, because that's one of the most important things that my clients say is I don't want my kids to fight. I want them to be friends. I want them to see each other at Christmas and Thanksgiving. I want them to have good relationships, and I don't want this to mess them up. And money typically does. It can. So that's my answer there.
It says, John Smith's supposed to get it. When it went to probate court, the question was asked, well, how do we know this is the John Smith that he wanted to give it to?
Right. So
Someone says, well, you should put social security numbers on it. But I said, no, you shouldn't do that in wills. So we didn't know what to tell him.
general, like John Smith, Juan Martinez, like San Antonio, we've got some common names, right? So if it's your child, Joe Smith Jr., born on this date, right? You identify by date of birth, and you identify your heirs. We like to identify in a section R documents. I'm naming, these are all of my descendants. I've got 3 kids, these are their dates of birth. I want everything split between them. I've got this cousin that I don't want him to get anything regardless of what happens to me. And if anything changes, I want no possibility that this person gets anything. We list that in that section as well. So identifying parties as clearly as you can. I would never recommend social security numbers. If we've got multiple people with the same name and the same date of birth, we can be creative about what to do there, but social security number is probably not the answer. I would do probably last 3 driver's license number. Okay, perfect. So one of the questions I get, because it's a hot topic amongst sort of your peers right now, is what about a ladybird deed or a transfer on death deed? I want to leave my property to my kids and I don't want to go through probate, and I hear that you can do that. The answer is it can. Are you a good candidate for it? Maybe. And that depends on how you're leaving it and who you're leaving it to. You're leaving it to one person. Yes, probably a solid idea. But either one of those things will help you avoid probate and will not violate the Medicaid issues that we talked about earlier. You'll keep your senior homestead. You'll keep your homestead generally. So yes, multiple people, it starts getting complicated because to sell that property, one wants to keep it and live in it. The other one wants to sell it. So now it's a negotiation between those two people. Who's going to pay the mortgage in the meanwhile? Who's paying the property taxes that have just gone up exponentially because the senior exemption, the homestead's gone? Who's going to hire the realtor? Which one are you going to use? What's going to be the listings price? Every contract, every agreement has to be double signed. The buyer is now asking for concessions. We need to spend $20,000 fixing this in the house. I'm not giving you $20,000. You can pay for it. Your share. You make more money than I do. Have this conversation every week. Every week, guys. So, there is risk. A ladybird deed, transfer on death deed, is a great solution for a limited number of people. Is it a solution for everybody? Absolutely not. Yes, sir.
So with the ladybird deed, it's passing outside of probate. And what the person who actually gets the property by the ladybird deed, what is going to be their basis? Is it going to be the basis like the fair market value at the time of?
That's a very good question. I like the tax questions. Get a little thing that's a little spicy. So you get a step up in basis to market value at the time of death. So if you inherit mom and dad's house and their basis was $100,000 and it's now worth $750,000, if you get a step up in basis, the value that you take it at, your acquisition price is $750,000. So if you sell it for $750,000, you pay no capital gains tax. If you gift property to somebody in your life, I'm going to give you this office building. I bought it for $500,000 and it's depreciated down to $200,000 and it's worth $2 million. That child is now, their basis is $200,000 and they're paying 23.8% long-term capital gains tax on the delta. So gifting is highly problematic. The estate tax exemption, death tax, does not exist for most folks. The exemption this year is almost $14 million per person. So a married couple has $28 million of exemption to use during your lifetime. So if you don't use it, you don't need it, great, no problems. But if you gift somebody during the property during your lifetime, you're getting rid of the benefit of having that exemption amount. The other thing that people typically have to plan for with regards to taxes are retirement accounts. So anything that is they've contributed pre-tax, they've been getting the benefit of deferred tax long-term growth. It's left to somebody as a designated beneficiary. Pursuant to the Secure Act, they have to take it out over 10 years and it's ordinary income. Big mistake I've seen. Mom and dad left me an account. It's got $500,000 in it. Told Edward Jones, send me the check. Take it to the bank. Guess what? All of their income is now at 37%, and now they're paying 37% on the whole thing. And once the check is issued, it's gone. Like, I've had people in my office, well, I requested the check. It's done. You're now paying your share of the tax on that. It can be stretched and worked with a financial advisor so that you are taking a little bit a year over 10 years. That doesn't apply to husband and wife. There's an exemption to that. You can roll it over into a spouse's. Your kids cannot roll over your retirement account. There used to be tricks that we could use, but less so now. I will make a plug, though. Stewardship is important in communities like this, making a gift and a legacy for yourself. If you have a retirement account and your kids have enough, but you want to leave them something, you want to leave them that retirement account, there is a way that we can set up, or you can set up, a charitable remainder trust that says, over 20 years, I've got this $500,000, and my kid's going to get a little bit over 20 years. They'll get a chunk at a time instead of over 10. They'll pay their share of taxes on it. But at the end of 20 years, based on the principle of long-term growth, usually, if the math works, that same amount that you were going to leave them outright can now be left to the nonprofit or church of your choice. So they get that benefit. So though you may think, I don't have enough to leave to make a gift, to make an impact, if you have a retirement account, you can set it up so that your church, your preferred university, your preferred nonprofit gets the tail end of it. It's called a charitable remainder trust. And it's not a difficult thing, and it's not that expensive. Roth IRAs are post-tax dollars. There is no tax on them when you leave it to a designated beneficiary. That's a good, important designation. So usually it's traditional IRAs and 401ks have that problem. Any other questions? Well, I think that we're at time. I am happy to answer anybody's questions in private. If anybody wants to have a meeting with me, you can call the office. I've got flyers. Anybody that's here gets a free 30-minute consultation. That doesn't mean that you have to hire me. If that means you want to ask me questions in 30 minutes in private, not in a room full of people, you are welcome to do so. But thank you so much, everyone, for listening to me talk today and answer questions. And thank you so much, Joe, and thank you, church.
And thank you for the email, and I don't know whether it was you or your marketing director, but thank you for reaching out to the community.
Oh, it's my pleasure.
And this is very informative, I think. I learned some things. I probably did some things wrong with my dad's account and my brother's accounts. And I hope that the government doesn't find out.
We won't tell them.
But, so Shann will be with us. He'll be having lunch at a table. And, if you need to ask some questions, take advantage of that.
I'm 100% here too during lunch. So if you want to ask me questions during lunch, I'm fine with that as well.
Make sure you let him eat. Let me pray, and we'll go on to lunch, and make sure that you sign up for things coming up this month and for the Christmas party in December. Thank you, Lord, for information that we've learned today. Thank you for Shann. Thank you for his willingness to reach out to the community, and we're just thankful for the opportunity we have to at least get some understanding of maybe some areas we need to look into. Thank you for our time together at lunch. Thank you for those who prepare it. Thank you for those who will be serving it. And I pray that you give us good fellowship around these tables. Thank you for this group that you have bound together and that you have given opportunities to share together in significant things, and for the opportunity we have to develop these friendships. Go before us today. Help us to do and say what you would have us to do and say throughout the rest of the day. In Jesus' name, amen.
Amen. Thank you so much.